So welcome to our 11th webinar in the Contemporary Challenges in American Global Law series. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LLM program, in which Catholic University has cooperated with Jagiellonian University in Kraków for many years. I will be your moderator. To open, I turn to Stephen Payne, Dean of the Catholic University Law School, from greetings from our law school.
Thanks, Professor Wortham. It's so good to be here with all of you. Welcome from the Catholic University of America in Washington, D.C. We're very proud of our deep and long relationship with Jagiellonian University. Welcome to all the students and alums of both schools, and especially the alums of our joint programs together. Really wish that we could do some of this in person, but I'm happy that Professor Wortham and this whole team from both schools have been able to put this series together so that we can continue to develop in our great relationship even in COVID pandemic times. So, and happy that the virtual platform may give some who would otherwise be unable to participate an opportunity to participate. My greetings to Dean Pisulinski. Very good to see you again, sir. And I am just very glad that you're all with us, and we'll turn it back over to Professor Wortham.
Thank you. So I now will ask Jerzy Pisulinski, the Dean of Faculty of Law and Administration at Jagiellonian University, to bring his greetings as well.
Good afternoon, everybody in Washington, and good evening in Poland. So I would share the same thanks to Leah and the whole team in Washington, in Catholic University, and in Kraków, in Oxpo, and Center for Foreign School of Laws, for organizing this series of webinars and this good opportunity to continue our cooperation, which lasts many years. And I hope this the next step of our cooperation, scientific cooperation. Not only we educated, we teach students, but also we want to develop our cooperation in area of research. And this one of these events when we can share the outcome of our research. So today we'll speak professor from Catholic University and a professor from Kraków University. So I'm very happy that we can continue this cooperation, and I will wish you interesting discussion. However, this topics is not my topics because I deal with private law. But this week is I started from the crime. Yesterday I was a chairman of the public defense on proxy crimes. Today I will open the next seminar on the juvenile crime. So I don't want to think what would be tomorrow, what will be the next day. So again, I would welcome all participants, all alumni from both School of Laws. So I wish you pleasant discussion, interesting discussion. Thank you.
Thank you so much. Dean Payne and Dean Pisulinski's strong support has been critical to this webinar series. The series is supported in Poland by the staff of the Jagiellonian Center for Foreign Law Cooperation, which is often referred to by its Polish acronym OXPO. We're pleased to have with us today Piotr Szwero, OXPO's director, and Wojciech Wańczyk, who is the coordinator of the American Law School. Lena Helińska designed the beautiful and informative website for both the webinar and for OXPO. Juliana Kobyrzynska, the international relations specialist at the Foreign Law School Center, has been supporting OXPO now for more than 20 years. The webinars also are supported in Poland by our LLM coordinators and graduates, Gaspar Kot and Luke Bartosik. The webinars are made possible at the Washington end through the hard work of the staff in the university and law school's development and alumni relations and the law school's media staff. Louise Leiden, our executive director of the law school's office, so you can see on the screen, our alumni director, Kate Smith, Christina D'Amelio Lopez, our advancement director, Jean Emery, the office manager, Joe Ferraro, our director of marketing and communication, and his staff members, Jillian Salazzo and Al Washington. Many thanks also to the university's advancement office, where Michael Graham Cornell leads the tech support for the registration and webinar technology. And all of hard work from all of these people was necessary to make this possible. We hope you will join us on March 24th for the final webinar of the winter series. The links for the 4 spring series webinars on April 14th, 27th, May 12th, and June 2nd will be on the website shortly. Now we turn to today's program by Professor Cara Drinan, followed by comments from Professor Wlodzimierz Wróbel. So I expect most of you have been using Zoom before or similar video conferencing platforms, so you know about typing questions in the chat. I will be taking the questions in the chat and posing them to their speakers. You can type them in directly. If you prefer, you can use the drop down from everyone and send a question directly to Wojtek Banchik or to Gaspar Cote, and they will pose it for you or send it to me. In addition to the chat button, you can see the participants button will let you know the names of the people signed on. You can also, if you would like to send a private message, you see someone you haven't seen for a while, you can hit the drop down in the chat and change from everyone to an individual and say hello or ask a question or whatever. We're sorry that the registration software doesn't recognize all the Polish characters, so I see a question mark in someone's name. Sorry about that. And if you register and you just use an English character, we'll avoid that. So Professor Drinan will speak for about 20 minutes. She'll be followed by a comment from Professor Wróbel, who will also lead off the question and answer period. So the session is being recorded and the 60-minute webinar will be posted on CUA's YouTube channel within a few days. The series website also links to those recordings. At the end of the 60 minutes, I will announce that we're closing the recording, but Professor Drinan and Professor Wróbel have graciously agreed to stay on for up to a half hour so we can take more questions. So I encourage all of you who can to stay on because that last half hour is usually very lively. So in the chat, you will now see links to bios for Professors Drinan and Wróbel, and I will read briefly some highlights from those. Professor Cara Drinan is both a professor of law and our director of faculty research. She is a nationally recognized expert on right to counsel, juvenile sentencing, and criminal justice reform. Professor Drinan, who teaches criminal law, criminal procedure, and criminal justice reform, among other courses, also serves as the director of faculty research. Her research focuses on counsel, access to counsel, sentencing, and youth in the criminal justice system. In 2017, she published her first book, which was on juvenile sentencing in the United States, The War on Kids, How American Juvenile Justice Lost Its Way. Since that time, she's been advocating nationwide for juvenile justice and sentencing reform, an area certainly in need of reform. Wlodzimierz Wróbel has been the chair of criminal law at Jagiellonian since 2012. In 2011, he was appointed a judge in the criminal chamber of the Polish Supreme Court. In addition to leading Jagiellonian's criminal law department, he also heads the Department of Bioethics and Medical Law and directs postgraduate studies in both departments. Professor and Judge Wróbel has published over 100 academic works in criminal law, constitutional law, and legal theory. With Professor Andrzej Zoll, he co-authors the commentary on the Polish Criminal Code. In 2020, the Court Watch Polska Foundation named him the Citizens Judge of the Year, citing his efforts in legal education, raising legal awareness in Polish society, and communicating directly with the public. I first met Professor Wróbel in 1997 when he was one of the original team establishing the Jagiellonian Legal Clinic, as was Professor Pisulinski, who was also part of the original team. And Professor Wróbel headed the clinic from 2005 to 2008. Professor Wróbel is one of the most well-known and respected scholars and judges in Poland, and we're deeply honored to have him join our series. So we now turn to Professor Drinan. Please remember to type your questions in the chat to everyone, or you can send them individually to Wojciech or to Gaspar Cote, and they will pass them on or type them in the chat. So thank you.
Thank you, Professor Wortham. Thank you to Deans Payne and Pisulinski. Thank you to all the staff and students and administrators who've gone above and beyond to organize this event. I appreciate the opportunity to talk to all of you. And thanks to so many of you for joining us tonight 6 hours ahead. This is the end of your day, I know, so I appreciate that. I want to just jump right in and talk about how I became interested in this issue of juvenile sentencing. And as Professor Wortham mentioned, in 2017, I published a book, and I published this book called The War on Kids, because for years as an academic, I had been writing law review articles, right? Journal articles, which is what academics do. They write about very granular and technical issues that can inform and hopefully reform the legal system. And the book project was really a project designed to communicate to academics, but more importantly, to just mainstream American readers, international readers if possible, the fact that the United States is the most punitive democracy in the world when it comes to justice-involved youth. And I just have been so stunned over the years as I've talked about this research issue that people don't know that. They just simply aren't aware of the extent of how cruel and relentless our criminal justice system is for kids in particular. So since that book's publication, I have been on the road, so to speak, in lots of different contexts, trying to convince lawmakers and voters and citizens that this is really important and it's something that we can change. So today, as Professor Wortham said, I'm only speaking for about 20 minutes. That's really very little time. So what I'd like to do in that 20 minutes is essentially tell a story. And the story has 3 parts. And so part 1 of the story is just to explain the central claim of my book, right? That the US waged a war on kids in the last 50 years or so. And part 2 is that the story has some hope coming, right? That there's been some positive recent reform developments. And then at the end of the story, I want to talk about where we are today and what I think is realistic and probable in the years to come in terms of juvenile justice reform. So as I said, I know that's a very tall order for 20 minutes, and I'm going to cover some issues at a high level. But my hope is that you should feel free to circle back to those issues and we can go deeper during question and answer. Okay, I'm going to begin the story by telling you about someone who has become my friend, but whose case before the United States Supreme Court really marked the modern era of juvenile sentencing reform in the United States. And his name is Terrence Graham. And when Terrence was 16 in 2003, he and 3 friends attempted to rob a barbecue restaurant in Florida. They entered through a back door after closing. They fled when the manager confronted them. They left with no money. One of Terrence's co-defendants struck this store manager with a metal bar and sent him to the emergency room needing stitches, but fortunately, no one was seriously injured that night. And Terrence was charged for that crime with armed burglary and attempted armed robbery. And ultimately, he was sentenced to life without parole for his involvement in that juvenile non-homicide crime. Now, before sentencing him to die in prison, the Florida judge who imposed that sentence wondered aloud, as the record indicates, why Terrence would, quote, throw his life away when he had been given, quote, quite a family structure. And as I came to learn in my research, nothing could have been farther from the truth, right? The truth about Terrence's childhood is that he grew up in abject poverty, often going hungry, without utilities like water and electricity. Both of his parents were addicted to crack cocaine during a period in this country when that was just an epidemic running rampant through Black communities in particular. Terrence endured neglect as well as physical and verbal abuse that was documented by social services dating back to his toddler years. And by 10th grade, which was the year of his involvement in that attempted robbery of the barbecue restaurant, by 10th grade, he had attended 9 schools because his family was moving so frequently from one subsidized housing unit to another. So I mention this to say life was violent and chaotic and traumatic for Terrence, despite what that sentencing judge said. And again, what I came to realize in my research is that Terrence is not alone, right? As the title of my book suggests, in my opinion, the United States has waged a war on kids. And like most wars, this war has had its biggest impact on poor, minority, and otherwise vulnerable kids like Terrence. So this is what the war on kids looks like today. Today, nearly 50,000 children are locked up in America on any given day. Prosecutors routinely take children out of juvenile court and charge them in adult court as if they were adults. Youth who are charged and convicted in adult court are subject to mandatory sentences that were drafted with adults in mind. Youth can be kept, in fact, about 10% of our incarcerated youth are in adult jails and prisons, even though we know there's a mountain of evidence demonstrating that those are the locations where youth are at the highest risk for physical, sexual assault, and suicide. Even kids who are in juvenile facilities can be subject to things like pepper spray, mechanical restraints, solitary confinement. These are things that were designed for the most dangerous of adult prisoners. Until 2005, the United States was the only nation to execute people for juvenile crimes. 2005, that wasn't long ago. And today, we are the only developed nation in the world that still sentences children to die in prison. Okay, so how did this happen? How did the United States become this extreme outlier that we are when it comes to kids? And the war on kids, like mass incarceration in the United States, is actually quite a recent phenomenon. So by that, I mean that the United States invented the juvenile court model in the late 19th century. That's really the subject of a separate talk, but suffice it to say that that model, that notion of a juvenile court, it was not perfect by any stretch. There were lots of inequities and disproportionate use of those juvenile court protocols. But nonetheless, that model was predicated on this idea that a child who broke the law was typically in need of something, in need of a social service, in need of a gap being filled at home. And it was also predicated on the idea, an idea deemed intuitive, that children who broke the law should not be meting out the same punishment that we do for adults when it's a child who breaks the law. So over the course of the 20th century, every state in the Union developed its own juvenile court model, and developed nations around the world emulated this American juvenile court model. But as I discuss in my research, while we were exporting this notion that kids are different and should be treated differently in the court, we were simultaneously abandoning that concept here at home. And in order to understand how that happened, how we came to abandon it, I think it helps to think of the war on kids as really a subplot to the story of mass incarceration. And I'm not sure how much those in the audience know about the United States experience with mass incarceration, but let me just give you the basics, right? Which is, I'm sure you know that the United States leads the world in its rate of incarceration, that we have more than 2 million adults and children behind bars, and that this is a new dynamic, that this is a dynamic that really emerged post-1970. We have 5% of the world's prisoners, 5% of the world's population and 25% of the world's prisoners. So we are uniquely inclined to punish and uniquely inclined to turn to correctional facilities as our mode of punishment. As I often say, the land of the free has become the world's largest jailer. Okay, there are entire books written on how that happened, but let me just say in brief, beginning in 1960, there was a spike in violent crime in the United States, and it persisted about into the mid-90s. And in response to that spike in crime, and in particular violent crime, and in response to be fair, to citizens wanting a response, politicians on both sides of the aisle essentially competed as to who could be tougher on crime, right? And we put more criminal laws on the books, and we enhanced the penalties for violating those criminal laws. And so you don't have to be a mathematician to understand that as you send more and more people to prison for longer and longer periods of time, the correctional population simply balloons. And so today in the United States, 1 in 7 people behind bars is serving a life or a virtual life sentence. They will die in prison for the crime they committed. equally important about mass incarceration in this country is not just the numbers of who is behind bars, but the demographics of that, more particularly along class and race lines. Right? Mass incarceration has not affected all Americans equally. And as I said at the outset, it has had a devastating impact on poor people and communities of color. Happy to talk more about this during Q&A, but let me just give you a couple points on that. 4 out of 5 criminal defendants in this country are poor. 80% of people who are prosecuted for a crime in this country are poor. And while they are entitled to lawyers at the state's expense per our constitutional mandate, that rarely happens in practice, at least in an effective manner. And at the same time, Americans, minorities in America are exponentially more likely to be in contact with the criminal justice system at every stage of our system, whether it's suspension and expulsion of Black children in schools, or traffic stops, or stops and frisks on the street, or who is on death row. At every juncture in that criminal system, people of color are more likely to be negatively affected. So all of that is to say that our punishment practices in the United States are extreme. They have a negative and disproportionate effect on poor people and communities of color. And again, also a topic for a separate conversation. They operate not just as a form of punishment, but I would argue as a form of community excommunication. And what I mean by that is, in the United States, serving time in a detention or correction facility is just the beginning of the way in which we punish people. Okay, so I'm painting this picture, hopefully, of just an incredibly punitive regime that has become more punitive, even more punitive, in recent decades. So how do children enter this picture? Kids were swept into this movement toward mass incarceration, and really in 3 particular ways, right? Juveniles suffered from 3 particular trends in the last 50 years. The first is, I mentioned that politicians of the late 20th century were competing to be tough on crime. And one of the ways in which they legislated their tough on crime positions was to enact what are called transfer laws. And transfer laws allow a child to be taken out of juvenile court and prosecuted in adult court as if they were an adult. Lots of essentially 3, but within those 3 categories, lots of variations on how that can happen. But suffice it to say that every state in this country today has at least one provision that allows the transfer of a child with 0 minimum age, no minimum age requirement in adult court. So, and I want to be really clear about what that means for those who are new to this idea. It means that through a legal fiction, this legal fiction that's been legislated, we can prosecute a child as if they were an adult. Okay, so that was the first really devastating development for children in the late 90s. And as I said, nearly half the states now have not just a transfer provision, but one that is without a minimum age. Okay, around that same time, federal and state lawmakers introduced what are called mandatory minimums, or determinate sentencing schemes, sentencing regimes in which the judge does not have discretion. Right? And so this was really problematic for youth. It was the perfect storm, in fact, because as transfer laws made it increasingly common and easy for children to be in adult court, once they were convicted in adult court, they were subject to mandatory sentences that had been drafted with adults in mind. And then I would just add the third development in the late 20th century that was really devastating and continues to be devastating to kids today is what has been labeled the school to prison pipeline. And the literature uses that metaphor, I think, really just to describe the idea that in the late 20th century, schools became a pipeline, right? An on-ramp, an avenue to the criminal justice system in ways that they never were before the late 20th century. Largely that meant introducing security measures to schools that had been traditionally reserved for law enforcement measures, surveillance cameras, metal detectors, police officers being in school buildings, and coupled that with 0 tolerance disciplinary practices. In nearly half the states in America, it is a crime, it's a defined crime, to disturb school. And children can be prosecuted under that crime for things like being boisterous, annoying conduct, refusing to turn over a cell phone to an administrator, and talking back. These are behaviors that 40 or 50 years ago would have resulted in a trip to the principal's office. And today, unfortunately, they can result in the arrest of a child by an on-site police officer. Okay, so that's the very abbreviated version of how juvenile justice lost its way, right? In response to rising crime and fear about that rising crime in the late 1990s, as a nation, we accepted this idea that children, especially those who break social norms or break laws, are a grave risk to society and need to be contained, right? Rather than nurtured or met where they are. Okay. So let me turn now, having kind of introduced the idea of this war on kids, let me talk about a few things that have happened in the last 20 years or so that I view as very positive. Okay, the first and most important development is that I mentioned we have about 50,000 kids behind bars today. That sounds like a lot, but in 1995, we had about 100,000 kids. So in the last 20 years or so, we've been able to cut that number in half, and that is obviously huge progress. I would give a caveat to say that it is largely white children who have benefited from that decline. And in some states, nationally, we're seeing an increase in disproportionate minority contact, meaning more Black and brown children are going to detention facilities and white kids are not. But nonetheless, that's at least directionally the right trend that we want: smaller facilities and fewer of them. The second positive development that we hopefully can talk more about during question and answer is that beginning in about 2005, the United States Supreme Court began to rein in the extent to which the states could sentence children in the most extreme fashions. And so again, I can't go into great detail about these cases, but in a series of cases that is referred to as the Miller Trilogy, the Supreme Court eliminated the juvenile death penalty, eliminated sentences like the one Terrence Graham received, right? Eliminated juvenile life without parole for non-homicide crimes. And in Miller versus Alabama said, even when a juvenile commits homicide, the court must make a determination. It must determine that this is a child, the truly rare child whose crime reflects irreparable corruption, before imposing a life without parole sentence. So those cases have been, while they only dealt with the most extreme sentences on the books, they have been powerful tools for advocates because they stand for the proposition that children are scientifically different, right? The court in all of those decisions really leveraged brain science and social science that in the last 50 years has proven children are fundamentally different. They're not just small adults, they're developmentally different and therefore less culpable and more amenable to rehabilitation. So the court giving that science its seal of approval, its imprimatur, has been useful to advocates. And as I said, this notion that children are different has really trickled down to state sentencing reform. So that leads me to my third point of positive developments. The states are really heeding the message of those court cases, right? Sometimes the United States Supreme Court can't enact social reform in a broad level, right? In fact, most of the time it cannot because of institutional competencies and constitutional limits. But what it can do is use its moral authority to spark reform. And in the juvenile space, it has certainly done that. So for example, in 2011, only 5 states in the union banned juvenile life without parole, right? The supermajority of states thought juvenile life without parole was not problematic. And today, nearly half the states in this country ban juvenile life without parole. And that is exclusively in response to those juvenile sentencing cases being handed down and advocates picking that up at the state legislative level. So that's great news. Another piece of great news at the state level is that states began to implement parole review practices for kids, now adults, like Terrence Graham, who had once been told they would die in prison, to give them a second look. And about 700 people who were once told they would die in prison, right? As children, they were told they'd die in prison. About 700 of those individuals have come home and by all accounts are doing beautifully, right? Recidivism rates are incredibly low. And so that's a really positive sign. Okay, I'm almost out of time. So I want to just close by talking about what I think needs to be done going forward, right? In my talk, the title is something about path forward, progress and the path forward. So let me just flag a few things that I think will be really important for the path forward. we have a lot of work left to do, despite those positive developments I just talked about. And I think, especially in this moment in 2021, given where we are as a country, the most important thing that we need to do if we want to see better outcomes for justice-involved youth is to keep our eye on the idea of reforming our entire criminal justice system. Right? So I mentioned at the outset of my talk that the land of the free has become the world's largest jailer. That's not because we are more criminally inclined, right? It's a policy choice we have made about how we want to respond to antisocial behavior, right? Rather than pro-social engagement. And so that's a really important thing, even if you are exclusively focused on kids. And here's why. The status quo today is affecting children who haven't even become in contact with the criminal justice system. In this country, nearly 3 million children have an incarcerated parent. And you can guess which populations are devastated by that statistic, right? And we know that having an incarcerated parent is related, that is indicative of future contact with the criminal justice system for that child, right? We spend nearly $200 billion a year on mass incarceration in this country. And that money is crowding out expenditures we could be making on things like education and social services that keep kids out of the system. So I want to be clear, this does not have to mean defunding the police, although I think that term is misunderstood. It does not have to mean defunding the police, but it does mean that we have to rethink our instinct to address every social problem we encounter by incarcerating people. We have to rethink that national instinct, and we have to think about things like poverty and substance abuse as public health issues rather than correctional issues. Let's see, I know I'm very short on time, so let me just say a couple more things that I think we need to focus on. Given where the United States Supreme Court is today, it is not the same court it was in 2005. It's not even the same court it was in 2012 or 2015, some of these really salient cases that I referred to earlier. As I'm sure most of you know, it has pivoted and become a more conservative court, although much of that remains to be seen, at least in the sentencing space. But given that, it almost doesn't matter the composition of the court, because about 90% of people in this country who are incarcerated in a state correctional facility. This is not a federal issue, it's a state issue. And so I think we really need to urge our state lawmakers, as I said, to continue leveraging those Supreme Court decisions, the science they put forward, the moral arguments that those decisions put forward, and really aggressively pursue age-appropriate sentencing reform. So not a get out of jail free card for kids who commit crimes, but an age-appropriate and a developmentally appropriate to respond to children who, as I said, I use the term violate social norms because I have a hard time thinking about disturbing schools as a crime, for example. And the last thing I would say is that in this country, and I've alluded to this, is that we really need to dispel the myth that incarceration is a tool for public safety. Too often in this country, people talk about incarceration as a tool for public safety. Yes, there are instances when people need to be incapacitated as a means of public safety. But certainly when we are talking about the juvenile population, it is a very small percentage of even juvenile arrests that involve violent crime rather, right? So there are so many children in the system whose crimes reflect social needs, educational needs, trauma history. And we really need to recognize that, at least in this country, I'd be curious to hear about what it's like in Poland, but at least in this country, prisons are brutal and dehumanizing institutions. They are not places of rehabilitation, right? So we really need to rethink that and recognize that, as our recidivism rates indicate, our extremely high recidivism rates, that we are not doing anything corrective or therapeutic in those facilities. So as I said, we need to stop thinking of incarceration as a tool for public safety and rather as a threat to public safety, especially when we're talking about children. Okay, I will stop there, and I look forward to hearing the professor's comments and comments from the audience. Thank you for your attention.
I think that Leah told me that I can speak. I hope so, at least.
Yes, that's right. I forgot to unmute.
Thank you. There's always a problem. Thank you so much, Professor Drinan, for this presentation. I've got so many questions after what you said. But first of all, I was trying to imagine when I'm looking at the list of the participants, and I see many Polish names there. So I was just trying to imagine what was the basic question that we should clear up at the very beginning. We're talking about children. What do you mean by children? What age, what frames? I mean, because perhaps it would be also interesting for us to know what is the average age of a child in incarceration states now.
Yeah, that's a great question. So the first question you asked, what do we mean by child? So a child in the United States typically is defined as someone under the age of 18, right? And I say typically because there are a handful of states in which they have set the age of majority at a younger age, meaning that by default, a child of 15 or 16 can be charged in adult court. They don't need to be transferred because they're an adult once they reach 16, right? But by and large, the age is 18, and the Supreme Court has also used the dividing line of 18, largely because that is what we use throughout our society in general for things like voting privileges and enlisting in the army and so forth. But I will say a number of really progressive states in recent years, because of the recognition of brain science, have moved toward what's called raise the age legislation. So for example, in Vermont, they're moving to expand their juvenile court services into the early 20s. That is more consistent with brain science, right? We know from the brain science that a juvenile's brain is developing into the early to mid 20s, and that frontal lobe of the brain is what controls things like impulse control and planning and assessment of long-term risk and consequences. So by and large, we're talking about those under 18, but I would suggest that the science would say we should be talking about people up to 23. And then to your second question, Professor Wróbel, I would say the average age of those who are serving time in a facility, rather than just being in contact with the system, is 16 to 17.
Okay, I'm just putting this question because in the Polish system, the criminal liability starts with 17s in general, the principle, and in a rare occasion with the very grave crimes with 15s as well. So it might be not so different to what you told. Maybe if there are many cases when, for example, in the States, the 13-age teenager or 14-age teenager is also very often to be found in the courtroom for the adult. Yes, in the other courts. That was the question of the average age of someone who is in the prison. Yes, but let me think about something else. Yes, when we cleared up this first question, because certainly in Poland we follow totally different model. So it is so-called discretionary welfare-oriented models. So when we think about the interest of the child, not of the criminal responsibility, though in this limits of 17, 18, we are very similar in the reaction of the system. But let me ask first: do you think that being tough on punishment at all? You mentioned it a little bit. We have always, dealing with our American colleagues or discussing criminal law with our American colleagues, we have always to face this fundamental problem of the death penalty, on the acceptance of the death penalty in the United States. Don't you think that being tough on juvenile has the same root, cultural root, as being so acceptable and open to the death penalty?
100%. Yes, I couldn't agree more. I think, we are incredibly punitive as a country, and that is certainly reflected not just in our juvenile laws, but in our death penalty practices. And interestingly, to the extent that we see reform happening in the juvenile space, around those same years, so like, let's say the last 25 years, we've also seen for us what is tremendous reform in the death penalty space. So for example, since about the late 1990s, juries have handed down increasingly fewer and fewer death sentences, and states are actually executing fewer and fewer people. I live in Virginia, which for those of you who are listening from abroad may not be aware, is one of the it is the single most executing state in the nation in terms of history. So Virginia has executed more individuals in the nation's history than any other state. Our first execution happened here in 1608 as part of the Jamestown settlement. So we started early and we've kept going since then. And Virginia is poised to abolish its death penalty. And that is because over the last 25 years, we've seen through social science and really rigorous empirical work that there is massive racial and class-based inequity in who gets the death penalty in this country, and that we get it wrong, right? The Innocence Project movement has revealed to people that we get it wrong in our system, actually with some frequency. And so I think, but to get back to your original question, Professor Wróbel, yes, I agree. And I guess what I'm saying is we are seeing reform, but I would imagine to the ears of those listening from Poland, this does not sound very radical, this reform. It's pretty modest, right? Mm-hmm. And it is. I want to acknowledge that. I mean, even as we are seeing fewer and fewer executions, if you look at Gallup polls or Pew Research polls that do really rigorous assessment of national sentiments, still a majority of Americans want to see the death penalty on the books and available as a punishment. So yes, I think that's fair. We are an incredibly punitive nation, and I have some ideas on why that is the case. But yes, I would agree with that.
You know, as I mentioned, we follow in Poland the other model. So on the child interest concentrated model with a great discretionary power of the judges, the juvenile court, called the family court, with a very informal procedure, and it is criticized a lot because there are no safeguards, no proper legal advice, no proper consideration about the fault, the blameworthiness, the guilt, let's say, yes. So we are treating the children in a very paternalistic way, though we are dealing with the crimes. And normally, perhaps sometimes the court for the adults will be much more safer for the child than the family court. You mentioned it a little bit at the beginning. Because juvenile court was not a perfect one, yes. But while listening to you, I just was wondering if that is the idea of many scholars in Poland. Let's make this procedure more safe with more guarantees for the child.
For the child, you mean?
Yes,
for the
of course. The best way would be to transform this procedure. I don't think about the court into a model of the criminal procedure, which is very safe for the accused person.
Like that.
Somebody is talking to also.
Yeah, sorry, I couldn't.
Maybe it's much interesting than my questions. But you know, is it a price, or is there not a danger that transferring or let's say creating these safeguards, procedural safeguards, adversarial procedure, not inquisitorial one, for example, yes? So maybe the price for that is that we will start to treat the juvenile as adults with the guilt we've just deserved, with the proper punishment, with justice. We then stop to think about rehabilitation that needs an informal procedure, and we transform it into a very full of guarantees procedure, but then we pay the price with the punishment, don't you think?
It's a really interesting observation because those who study juvenile justice in this country talk about different eras in juvenile justice. And in the 1960s, I would say, we had what was called the due process era of juvenile justice, when the Supreme Court essentially started doing what you just alluded to, saying, wow, you know, we have this paternalistic notion of a juvenile court, but it's not working out very well for kids, right? Judges are not uniformly being lenient or child-centric, as you would say, and they have no right to counsel. They don't have a right to confront witnesses against them. They have no procedural safeguards. Well, once the court instituted that, you know, for example, the right to counsel in detention proceedings and the right to have those basic procedural safeguards, what we've seen is that they just don't have the bite or the teeth that we might think that they would, right? So if you look, for example, in the adult arena, well, in 1963, the United States Supreme Court said that if you're poor and you're hailed into court and you're facing a deprivation of liberty, you get a lawyer at the state's expense. That sounds great, but 60 years later, that has never been implemented at the state level. And I would say the same has been true for kids. We instituted all of these procedural safeguards, and they're not working out in practice. So for example, you know, if you look at the right to counsel in detention hearings, parents waive on their child's behalf, they waive the right to counsel a lot because they think, I'm worried I'll get a bill. I'm worried my child will get a stiffer sentence if we're deemed uncooperative. So it hasn't been a cure-all for us. The procedural safeguards have not been a panacea. And as you said, with these extreme sentences still on the books, it's just not enough of a stopgap.
When we mentioned the parents, yes?
Yeah.
That's another question. Because you said that society is very tough with the juvenile. So I have just the same reflection that sometimes when I see a person of 17 in the courtroom, even in the Supreme Court, I'm just thinking that perhaps the society would like to get rid of the problem somehow by the criminal law. Because asking ourselves who is guilty for this child being in the courtroom would be rather uncomfortable for us, yes. As the society, as the community, also parents and neighbors and all people who had to deal with that, maybe social care officers as well, the state itself, yes. So it's better just to deal it with the criminal way when we are concentrated on the act. We are not asking what has happened before. We are not asking what was the cause of the whole activity of the child. And we have a good conscience at the end of this, yes. But you know, this is the idea, Mai. We are very tough when the child is committing a crime. We are very tough on that. But in the same time, at least in Poland, I don't know, that is my question. The position of the child in the family, because of the very open discussion about the violence in families, yes, is being more and more bigger. So in Poland, it was finished with it is forbidden to slap even a child, even in educational goals, yes. So it is a crime. Many of very traditional measures of education, I mean, in the family, are now treated as a kind of a violence, unacceptable violence against the child. So I was just wondering if it would be possible in states, as it is, I think, forbidden in Poland, to punish the child by the parents for something, a kind of infraction, so something that constitutes the crime, perhaps a theft, yes, against the parents, yes, to punish it with some deprivation of liberty at home. So let's think about the 2 week in room, yes, closed room, but closed by the parents, not by the state. Would it be acceptable in states? I think not, but I'm not so certain. So what I would like to say, that in the family life, let's say in a normal social life, we are treating the child much better. So I think we are thinking about its rights and about his stronger position, even against his closed, yes. But in the same time, when the state is coming to the home with the policeman or the prosecutor, so we are very tough then, yes.
Yeah, so there's a lot in that comment. I want to unpack two pieces of what you just said. The first relates to this idea of social responsibility for a child who commits a crime. And then I want to come back to this idea of, you know, what can parents do versus what can the state do? So let me just say on the first point, I completely agree with you. We, in this country anyway, I'll take your word for it on the Poland aspect, but in this country, we do not take responsibility for a child who acts out and who breaks the law. And so that's why I began with the judge's comments from the bench, right? Where was the state of Florida when Terrence and his brothers were roaming the streets of Jacksonville, hungry, unclothed, untended to? Why was there no social intervention? And are we really surprised that after that trauma history, there would be some behavior that violated social norms? So I don't think we take responsibility for that at all. And I think, unfortunately, a big piece of that is because in this country, we are focused on political expediency and what results are fast. So in our election cycle, you don't get reelected by saying, let's take a really holistic view and look at things like structural inequality and structural violence and the fact that most children who come into the system have a trauma history. right, are living in communities ravaged by gun violence, are living in food deserts, are living in broken school systems. We don't ask those questions, right? Instead, we enact a law that quickly responds to a violent crime and we ratchet up the sentence. So I agree with you, that's a big failing of ours. And then the second piece on parents versus the state, it's very different here, as you know, so we were talking about this briefly. Parents can spank their children. In some schools, paddles and so forth, spanking with a wooden paddle is still an acceptable form of discipline. And so I think all we can say in our defense is at least it's consistent, right? And I say that with sarcasm. But I think, why do we do that? I think, to your point of could a parent put their child in the room? I think they could, as long as they were feeding them and providing for basic necessities. We call that grounding your child. There's a word for that. We call it, oh, you're grounded, meaning you can't go out, you can't see friends, you can't do things that you are usually free to do. And I think our focus on giving families that freedom is actually part of the problem. Right. So Professor Wróbel and I were talking before this webinar about the fact that the United States has not ratified the United Nations Convention on Rights of the Child. We stand alone in not doing that, right? We used to be in the company of South Sudan and Somalia. Now it's just us. And the reason for that, one of the reasons that those who say we should not become a ratifying state is because of this idea that we don't want to be told how we can discipline our children in our own homes. This idea that Americans are family-based and it's a private, not just a states' rights issue or a church issue, but a family autonomy question, that we should be able to punish our children as we see fit. So I think you're absolutely right, Professor, to identify the at-home issue as really closely related to the criminal system.
Thank you so much. I have many other questions, but there are others that would like perhaps to question you.
Great. Thank you so much for your thoughtful questions and comments.
So we have about 8 more minutes of the recorded session, and I'm going to ask a question that Artur Jagiello asked, but we just keep going on seamlessly. So as those of you who are thinking about more questions, please put them in the chat. Also, though, this conversational style is great too. So we can easily keep going with questions back and forth between the two of you as well. I think something that Professor Wróbel again was doing well is, perhaps in this topic, much more than many others, some of our other topics have been about the international economic system, where there's not really so much difference in terms of what happens in Poland and what happens in the United States. But here, there are so many different assumptions about the way the system works that I think doing that mediating is really helpful. So Artur Jagiello asks, and this is a similar question in a way to what we were already talking about, to Professor Drinan. Do you think that the harsh approach toward juvenile crime in the United States is partly caused by the Second Amendment, and hence by the wider access to firearms than other countries such as Poland? If so, do you agree that an abolition or a firm change of this fundamental constitutional provision could influence the way in which the US government tackles the aforementioned type of crime?
Yeah, I don't mean to look flippant when I sort of laughed at the question of whether we can rein in the Second Amendment. So it's a great question. I think it goes to, I would maybe reframe it a little bit more broadly, which is to say, is the same culture that insists upon individual gun ownership rights, is that part of the same culture that is okay with, permissive about what I think of as the violence we are doing to children, right? So that's how I think of it. In many ways, we are a culture of violence, right? I mean, about 40% of Americans say that they have a gun in the home. And if you live in a state, a very pro-gun state like I do, I'm from Massachusetts, by the way. So I'm a fish out of water in being in a southern state like Virginia. From that standpoint, Massachusetts is a much more progressive state. I never grew up with anyone having a gun in the home. That would have been unthinkable. But in certain states, like in this state, and as I said, about 40% of Americans have a gun in the home, and that's down from recent surveys. So I think there is something about our tolerance, clearly our tolerance for a level of violence I mean, you know, when I see, I'm sure you're all familiar with the tragic school shootings that we have experienced in this country. And when I see proposals for things like bulletproof desks and other security measures, it's as if we would do anything but look at the root cause of gun violence, right? We're willing to tolerate the gun violence, but not its outcomes. And so I do think that there's a connection there. I'm afraid I'm not optimistic about any limitations on the Second Amendment happening anytime soon. Just because, as I said earlier, the current composition of the Supreme Court right now, it's a conservative majority court who are originalists and textualists and who I think are very focused on protecting an individual's right to gun ownership. So I think we'll have to come at this from another angle.
I'm going to ask one question before we switch, and then we'll turn off the recording and keep going. But this is, in a sense, a similar question to Arthur's about, how about this? I was really struck by, I think, another Oxford book called Harsh Justice, which I read at some point, which had looked at indicias of harshness in our system. And just as Cara said, found that we weren't so different from Europe up until around 1970. Yeah. And then we took this sharp turn right, you know, where Europe, if anything, got a bit more liberal. And so it did other indicia of harshness, including what people are allowed to wear in prison, what they're allowed to do, make phone calls and so on. But one of their conclusions for the difference was how related our criminal justice system is to the election system, and how so much we have so many more elected officials. And one thing I sometimes kid around about is that every county prosecutor thinks he's next going to be state attorney general and then governor and then president. You know, they all see themselves just like Bill Clinton, rising up the level. And so Cara started her remarks about how much politicians were competing to be tough on crime. But for example, when you look at, in some cases, this almost unseemly competition between federal and state prosecutors of who can get the death penalty first, you know, when you have some notorious crime. So I'm interested, and to have both of you comment, this will probably go a little bit after 2 o'clock, about the difference in the degree to which the criminal justice system is controlled by elected officials versus people who are more civil servants, essentially, who are people within a career system. So first, Professor Drinan, and then Professor Wróbel should comment as well.
Sure. I mean, the short answer is I completely agree. You know, if you look at the bench in the United States and then ask where those who come from the criminal system, who have a criminal background, by and large, it's prosecutorial rather than defense. And there's a lot of people, there are many people who think that we need to actively work to change that, right? We need more of the criminal defense bar on the bench. And so I would agree with that. The other thing I would say is that, you know, and this goes back to the point I meant about political expediency and political viability, you know, the idea that if one is humane or looks to think about a rehabilitative focus, that one is soft on crime has led us down some really dark paths, I think. And so you mentioned Bill Clinton, for example, Leah. You may remember that when Clinton was running for president the first time, he was very concerned about being labeled soft on crime. And so he actually went back to Arkansas to oversee an execution of a man named Ricky Ray Rector, who was so intellectually disabled that when he was served his last meal, he asked his executioners to save some of it for him to eat after the execution. And so the horror of that, you know, the idea that any punishment theory would justify that execution. But as I said, Bill Clinton did that because it was deemed politically necessary for him to become president of the United States. So that says a lot about the electability aspect.
You know, I totally agree with you, Leah. We have many politicians now in Poland, but I think that it has also a social support, that maybe this system, when we can elect some prosecutor or general prosecutor, for example, but also there are some talks about some judges, let's say, of the lower instances, the judges of the peace, yes. So people who are thinking, who are baking it, I think that they are trying to establish some guarantees against authoritarian tendencies, yes, that when we elect, so it is our decision in that way, we could protect ourselves from some kind of a dictatorship of elites or politicians as well. Yes, but it has its price. And I think that what you mentioned, it might be this price. And in the time of the penal populism, it might be dangerous as well, yes? So we couldn't have a special guarantee and protection, and that we might not feel secure that at the very end, this electoral system in the judiciary will finish with the great incarceration, yes? But on the other hand, let me extend your question to Professor Drinan. You know, I was just thinking when we were talking about this very young juvenile, let's say 13, 14, such cases are pending also in the US courts, yes, in the state courts maybe. I was just thinking about the role of the judge in these cases. That is a little bit different than it is in the civil law states, yes? So I don't know, in these cases, probably there is a jury, or probably there is a plea bargaining as well. So at the very end, the judge is rather an administrative officer who is imposing the punishment somewhere in his cabinet, somewhere in his room, dealing with the papers, telling the truth. And you know, I'm trying to imagine such a judge. You know, I know that I will send a 13-year-old boy or girl to the prison for 2, 3, 4 years. Yes. Well, I can't imagine such a decision being a judge. Mm. The American judges do. Do they not feel responsible for the final, let's say, product of the administration of justice in the States?
Let me just intercede quickly. We're going to take Professor Drinan's answer to this question, and that's when the recording ends, but then we just seamlessly move on. And we have other questions in the chat, and I'll be picking those up. So Professor Drinan, if you want to answer that question, then we'll just turn off the recording and keep going.
Okay, great. Great question. I would say a couple of things, Professor. First, you're absolutely right that in many instances, the role of the judge is ministerial, right? Because as you said, especially the plea bargaining piece, 90 to 95% of cases in this country are resolved through plea bargaining. I don't know what the numbers are in Poland, but
much lower.
Much lower, right?
And it is not a real plea bargaining.
Yeah, I mean, we are a system of plea bargaining. It's not a bug in the system. It is the system, exactly. Right? And so to that extent, you know, obviously the judge needs to make sure that the guilty plea was entered knowingly and voluntarily. But unless the defendant is asserting his innocence, the judge isn't even required to find a factual basis for that plea. So it is, as you say, very ministerial. And even in the rare cases where someone has this, you know, virtually extinct experience of a full-blown trial, because of the mandatory minimums or at least bounded sentencing discretion, judges often don't have that much discretion. And then the last thing I would say is, I hope that judges would feel horror at the prospect of sentencing a child to any significant chunk of time. But one of the things that I have noticed in my discussions across the country is that I think we've all of us in the United States system have lost perspective on what is a long period of time, right? So I always ask at the beginning of my criminal law classes, you know, I'll always ask when we're talking about sentencing questions, well, how long, if you were a judge, how long would you impose? And I'm always sad, I guess is the best word, to hear when students or people in my audience will say, maybe only 15 or 20 years. It's like in any other developed nation world, 20 to 25 years is the upward limit of a sentence. But because we so regularly dole out 70-year life sentences, it's as if we've kind of all lost perspective.
I understand. That's a very interesting remark.
Okay. So we're now going to turn off the recording, but I'm going to move right on, and we've gotten